Being powerful is a bit like being ladylike. So if you have to say you are, you probably ain't. So I think I like America most of all on the days when people are not going around shouting, USA, USA, we're number one, we're the greatest. I prefer the days when they don't do that, when they're probably most to be admired.
What is it that makes us boast about our greatness and belittle others? What is it that keeps us from ascending beyond the immediate? I cannot help but wonder what Hitchens would say today. It is a thought that somewhat haunts me as I stumble through communicating a similar belief of many before me, that we are brothers and sisters of the human race, with core values shared among us, which are hidden in the labels and divisions we create.
And if you understand freedom, it's based on tolerance and nonviolence. So if it's tolerance, it should be bringing all kinds of people together, and that's following our Constitution. We shouldn't be fighting among ourselves, because we shouldn't be fighting in Washington. If we all take the same oath of office, where does the fight come from? Somebody is messing up somewhere.
Libertarians proclaim reducing government interference because all Americans should be free to live their lives and pursue their interests as they see fit, as long as they do no harm to another. That peaceful, honest people should decide for themselves how to live their lives without fear of criminal penalties, and that the government's responsibility, if any, should be protecting its citizens from force and fraud.
The ruling class has always taught and trained you to believe it to be your patriotic duty to go to war and to have yourself slaughtered at their command.
The socialist soapbox calls for a classless society with communal ownership and perspective that is driven to enhance freedom, justice, and solidarity towards a goal of peace. Peace, of course, includes police abolishment, which I must say is highly unlikely to ever be a reality, but it is the only ethical goal.
Right? Forget about effectiveness or not effectiveness. You don't get to confiscate my money just because you and your friends vote to take it.
The deliberate pragmatism of conservative thought espouses the value of moral order and building off the best of the past with long-term goals that are achieved mainly through community and family with an ideally restrained and fiscally prudent government.
People are born to be free, and that their basic instinct is the desire to free themselves from coercion, authority, and oppression.
The ideal liberal is said to believe in that natural goodness of human beings and the intrinsic value of individual liberty, that to have an honorable society, we must have moral equality across sex, race, birth origin, religion, gender, class, wealth, etc., which is achieved through nonviolent modifications of institutions.
With certain inalienable rights, that among these are life, liberty, and the pursuit of happiness.
America, America, America. Cannot help but believe we have steered ourselves quite off course. We are now reading Chapter 6 of Crimes and Punishments, the interpretation of laws. I know, judges interpret laws to account for the circumstances of the particular case. It sounds good and all, lest we forego our principles, lest we have an inconsistent as to why. The primary function must be the strengthening of the societal fabric for everyone. Interpretation is the codification of revenge and bias into a system that requires procedural justice, meaning the system treats all actions the same. As we explore the principles which I argue should be adhered to, it is important to note that when these principles are not followed, it does not necessarily mean that the worst case scenario is occurring. I am talking about the underlying philosophies. Humans do an excellent job in some instances of mitigating the inherent harms of their institutions. We should all take a moment to think about what policing in America would be like without the mitigating efforts of a lot of people with badges who are resisting the institution as much as they understand how to. The bias of judges in the United States is an example of exceptional human mitigation according to a significant amount of research. While the rest of the system that brings the cases to the judges is measurably biased in which cases are brought before the court, Judges seem to have been aware of, or for some other reasons, not as influenced by their biases in their rulings. Two places to explore that research are Does Unconscious Racial Bias Affect Trial Judges in the Cornell Law Library, and Research on Bias in Judicial Sentencing in the New Mexico Law Review. Links will be in the description. Right after we go over a little more about what crimes and punishment in the 21st century essays are, we will get to the interpretation of laws. Like most cops, the emotions felt when pinning the badge on my uniform for the first time was a source of immense pride, but also a shocking reality to the complication of performing a duty under the weight of such power and responsibility. The callousness of veterans cops and the braggadocious masculinity of the streets are immature expressions of the generations of trauma enacted on our brothers and sisters from a system oppressing us all. My internal fights with policing, whistleblowing, scholarly endeavors, reform efforts, and politics have failed in exhausting fashion.
And what I'm trying to say is that we are looking at people who are doing nothing new, and if we focus on the actions, then we can fix the things for next time. Because when you focus on people, we end up thinking we can chop their head off, they put a new person in and something will change. But if we don't focus on the methodologies and the institutions, then we will be totally missing
somebody, put them in a prison cell, do the paperwork, go back out and do it again. So what we really need is to change the incentives and disincentives so that no matter what the role, we're still going towards that objective that actually serves you.
More occupation, more vehicles, if your answer continues to be violent, because we have to understand that everything about policing is inherently violent. I have come in there with authority and told you what you will do.
I believe one of the reasons behind my struggles is that I had not laid out a consistent and intertwined philosophy of what in the hell I was trying to say. For the philosophical foundations of crime and punishment to be ushered into the 21st century, a reimagination of our institutions is necessary. Building off the famous works of Cesar Beccaria, I construct those pathways to the Enlightenment period of justice. Free will, sanctuary cities, gun control, eyewitness testimony, incarceration, and more must all work together for a prosperous society. Learning these lessons has been a brutal journey for me, and it is unlikely to be an easy one for you, but it is one that we owe to the future, to make a safer world for our children to enjoy life, liberty, and the pursuit of happiness. Crimes and Punishments in the 21st Century by yours truly, Michael Wood, is most conveniently ordered from the evil empire Amazon, because we are in that 21st century after all. For the enhanced and expanded audiobook, check out Audible. In the meantime, the philosophical half of Crime and Punishments, all 40-some chapters and then some, is being presented as a free podcast from iMember Media at imembermedia.com and will be available on all major platforms and direct from the publisher. Pause the video or see the links in the notes and prepare for the challenge and adventure of self-critical thought. Chapter 6. The Interpretation of Laws. The despotism of this multitude of tyrants, and more insupportable, the less distance is between the oppressor and the oppressed. More fatal than that of one, for the tyranny of many is not to be shaken off, but by having recourse to that of one alone. It is crueler as it meets with more opposition, and the cruelty of a tyrant is not in proportion to his strength, but to the obstacles that oppose him. The fewer the social constructs of division, middle class, working class, black, white, left, right, urban, suburban, rural, the more difficult it is for the small percentage of elite people to hold absolute power. With the classes fighting one another, they distribute the execution of oppression. The fewer the classes, the more clearly seen the cruelty of the tyrants is. From this biological vessel which can only interpret a world which it cannot see, trusting justice to the individual is not tenable. There is little that is less credible than an individual human's perspective when under duress. When power is clustered into specific social classes, those classes lose their credibility in the same fashion. Historically, empowered classes attempt to achieve control through a reliance on laws which appeal to and secure the authority of those groups. Even if the authority is as impressive as human being as there can be, the methodology is ultimately destructive. If some benevolent dictator were to have a perfect codification of social order, this would only be true for that time, in those conditions, in that environment. All variables of life change with time, and time is steadily ticking. It is insufficient to expect a society to bind itself with laws made of past traditions. The laws must stand on their own merit of applicability. To last, the rules must be the codification of the societal contract, rooted in the benefit of the whole, while never putting the masses above the equal rights of all. It is not for any one or any few to be so bold as to speak for the bond of unity. Judges are an example of the any one or any few. Judges are human beings. They cannot interpret the law. There can be no establishment of new law because of a ruling, else the door is open to disproportionate punishments and infinite opinions and interpretations. When there are as many laws as there are judges, ambiguity in the law exists. It is a tempting band-aid for when confusion is present to merely rely on the judgment of a few. It is a sickness that needs inoculation, not mitigation. There can be no personal search for the intent of the law. If uncertainty arises, the law must be rewritten to mitigate the harm of ambiguity in the societal contract. Laws cannot be static and shall often be rewritten, but not because of a judicial ruling. The society who authored the laws can be the only ones to interpret the laws in their recodification. The arbiters of the law, who are subject to the influence of perception and biology, cannot consider the spirit or intent of the law in any way which is reliable to speak for the whole of the community. The more time passes, this error in legislation gets exponentially worse. As the possibilities of perspective increase, the complexity of possibly valid viewpoints expands in proportion and influence upon an interpreter of the law. The more judges, the more laws. The more cases, the more interpretations. The more need for judges in a closed circuit of tyrannical complex legislation continues. The magistrate's role in the process is to facilitate and determine if the conditions of the event and findings meet the standards defined by the law established by the people. The inclusion of this magistrate's clause is necessary to prevent the law being dictated by the judges and not the societal contract. Though concise clarity is to be praised, the formulations of law tend to grow in increasing complexity over the evolution of time and experiences. As legislation grows, the harm of not following the magistrate's clause grows because when judges interpret the law, there is an automatic and unavoidably prejudiced selection of which legislation to lean on. The same argument follows to the police officers and any enforcers of the law. Division caused over the tyrannical rule of judges creates long-lasting harm to society. The United States is torn over a plethora of laws established by case law, America's judicial tyranny. Brown versus Board of Education of Topeka, Citizens United versus Federal Election Commission, Dred Scott versus Sanford, Roe versus Wade, Miranda v. Arizona, District of Columbia v. Heller, Plessy v. Ferguson, all examples. This is the known risk of power being accumulated in the hands of elite classes. From the police investigations of the wrongfully convicted to sibling squabbles and back to the establishment of law by magistrates, limited perspective prejudices decision-making. The human risk of inquiry is the formulation of a narrative and a pursuit of only the evidence which fits that story. In every case presented to the court, the adjudication of amends is a goal to be pursued but is subservient to the primary focus on the strength of the societal bond. The court shall seek a determination of either the exoneration of the accused or the assignments of amends to the offended and needs to mitigate the societal risk of the offender. To minimize the societal risk, monitoring or societal separation measures are considered. Decisions of liberty restriction must be directed with a mindset of protecting and separating from society, not punishing through confinement and marginalization. Imprisonment in a cage or freedom is an inaccurate view of the possibilities. Scandinavian countries have highly successful applications of this very principle. Simplicity is sought in the human condition, leaving us vulnerable to adapting binary thinking, left, right, man, and woman, when it is so much more. Binary, such as left and right, is either or, but the possibilities go far beyond. The visible light spectrum is a beautiful gradation of color that is but a small sliver of the truth of the light spectrum. The possibilities in the societal bonds can go far past just seeing past the rainbow to the three-dimensional possibilities of infinite space. Truth is then dependent on the consideration of vast options, and even more challengingly, the truth is dependent upon the perspective of the observer in that three-dimensional space. The law will contain errors, and every law should include a sunset clause. The possibilities to fix the errors are endless. When the interpretation of the law is restricted to the community and the legislation, the mistakes in the law can be corrected and the injustices restrained to a temporary time frame. In the hand of magistrates, the injustices can transcend time. The debates over Supreme Court justices in the United States exemplifies the problem of interpretation. A critical element of presidential power is the nomination of Supreme Court justices and is hinged entirely on how those judges can use interpretation to weld the legal system as a political weapon. Tune in to the next episode as we explore the obscurity of laws. The cloak of darkness of laws is another open door for tearing at the societal fabric.